All right, good morning, everyone. Today is Tuesday, the second day of March 2021. The Court of Appeal is presiding over Civil Appeal number 12 of 2020. Sean DeSilva, the appellant, against Adam J. Gibbons, the first respondent, and Ryan Heyrana, the second respondent. This is an application for leave to extend time and an application for leave to appeal. Mr. Richard Horseman of Wakefield Quinn is appearing on behalf of the appellant, and Mr. Benjamin McCosker of Walker's Bermuda Limited on behalf of the respondents. These proceedings are taken before my lords, the President, Sir Christopher Clark, Mr. Justice Jeffrey Bell, and Mr. Justice Anthony Smelly.
Yes, good morning, my lords.
Good morning. Thank you for being with us for what for you is 9 o'clock in the morning. Thank you, Mr. McCosker, for being properly dressed. But as you can see, on Zoom, we've decided to adopt a slightly more informal approach. But as I say, good to see you in the right kit. So far as timing is concerned, what I propose is that we should have a 10-minute break in 2 hours' time, and then go on till about 12 for time, and then break for lunch and resume thereafter.
Yes, shall we begin, my lord?
Yes, please.
Yes, it would please your lordship, I act for the intending appellant, Mr. Sean DeSilva, and my learned friend, as you know, Mr. Benjamin McCosker, acts for the respondents in this matter. And this is an application for an extension of time in which to seek leave to appeal the judgment dated the 6th of October 2020, in which the Supreme Court refused to set aside the judgment in default. My lords, the chronological history is set out on page 22 of the record, which is quite convenient to look at, which is the judgment of the learned Chief Justice.
Yes.
Yes, and you can just see in paragraph 8, the defendant was required to serve his defense within 14 days after the time limited for appearing or after the statement of claim had been served on him. In either case, the defendant's defense was therefore due to be served no later than Monday, the 9th of December, 2019. And on the 4th of December, Mr. Richardson filed a memorandum of appearance on behalf of the defendant, but failed to file the defense. Mr. McCosker, in fact, put Mr. Richardson on notice that unless he filed the defense on or before Friday, the 24th of January, then he would apply for judgment in default. In spite of Mr. McCosker giving Mr. Richardson that notification, Mr. Richardson failed to file the defense, and quite rightly, the defendants then proceeded to apply for judgment in default. And on the 18th of February, judgment in default was entered against the defendant in the case. You'll see in paragraph 11 that 14 days later, after learning about the judgment in default, Mr. Richardson filed a summons seeking to set aside the judgment in default. And we might as well just go on to consider the reasons for the delay. I mean, basically, in a nutshell, my lord, well, as you can see, in Mr. Richardson's own words, most regrettably, in preparation for the complex murder trial, which I was currently involved in, I mistakenly and inadvertently did not file a statement of defense, did not properly prioritize the requisite documents for this matter. However, it must be stressed in the strongest possible terms, this was an unintentional oversight on my part, not the fault of my client. And it might be helpful, just so we don't flip around too much, my lord, to see that Mr. Richardson, in his affidavit, went on to say, I'm looking at paragraph 12, where he stated in a defense, plainly stated the salient matter appears to be whether the boat was structurally sound and fit for recreational use in Bermuda's harbor. and literal waters. Respectfully, the facts demonstrate that the boat was clearly fit and sound for these purposes. Further to the point, the question whether the boat would satisfy the stringent discretionary requirements for assuring the boat had aged as much as the one in this matter. Would it be?
Mr. Horseman?
Yes.
Sorry, just in relation to that last sentence of the first paragraph, the facts of this matter demonstrated that the boat was clearly fit and sound for these purposes. There was no evidence to support that statement, was there?
No, there wasn't, my lord. I mean, it was just a bare statement stating that the facts, and in fact, Mr. Richardson didn't outline what those facts were.
Right.
So that's accepted, my lord. And I think my learned friend, Mr. McCosker, I think it's common ground that the insurance requirement was never sort of a live issue at this particular point.
Right.
And so we need not concern it. The primary issue in this case is whether the T-top, which is, I don't know how familiar your lordships are, the boat, which sits on the boat, could be permanently attached to the floor of the boat, which is the main issue in contention.
Well, the T-top and the center console.
Yeah. Well, everything that fits on the deck.
Yeah.
That's correct. Thank you, my lord. So, my lord, I was put in a difficult situation, as I'll take you to if I can just take you to page 38 of the record, which is Mr. Sean DeSilva's affidavit. And I'm looking at paragraphs 6 to 8. And this just gives you a flavor from his perspective, what was happening. And you'll see, just picking it up from paragraph 6, that he didn't hear much from Mr. Richardson until close to the hearing date of the 21st of August. When I learned there was going to be a court date, I received an email from Mr. Richardson 2 days before the hearing, which advised me that I did not have a case as the boat had been sold. And that email is at page 13. Page 13 of SD1. And Mr. DeSilva says this was ridiculous. In my opinion, the plaintiffs strongly refused to take the boat. They were the ones who instructed me to sell it, and there was an agreement reached between us. I would sell the boat. They would keep the net proceeds of sale. Mr. Richardson advised me I didn't have a defense. I wasn't sure where I stood. So I asked Mr. Horstman to take over the matter, and this was on the 18th of August. Mr. Horstman made inquiries and learned there was a hearing date on the 20th. I understand Mr. Horstman retrieved my file on the 19th and attended court, and the court then set the matter down for the following day. So Mr. Horstman basically had 1 day to review the documents, draft a new defense, attended court on the 21st of August, but the court refused to set aside the judgment, primarily on the ground I did not have a defense to the claim on the basis that a report from Mr. Sampson indicated that the center console could not be permanently secured to the hull, and therefore was not seaworthy. And you might as well just carry on, my lord. I deny that the center console could not be permanently secured, as indicated by Mr. Sampson. It was, in fact, already secured appropriately, but as a result, I reinforced the sole by installing a new fiberglass floor, which cost $3,845 to install. The boat has been in the water during the duration of Hurricane Paulette. Had no issue with the T-top remaining, with winds blasting up to 100 knots. And we might as well finish up paragraph 10, my lord, because it's relevant to the application for leave for permission for an extension of time in this application. I should explain that my delay in bringing this application to the court is that I'd hoped to settle the case with Mr. Richardson, who had negligently failed to properly represent me. My lawyer offered Mr. Richardson the opportunity to take the matter on appeal, but he did not agree to do it. There were ongoing discussions regarding settlement, but at the end of the day, Mr. Richardson would not agree to settle the case for any meaningful settlement other than to refund my legal fees. The time limit expired for filing the appeal, but I was hopeful we may reach a settlement which would allow me to avoid having to take the appeal forward. In the end, I was unable to reach an agreement with Mr. Richardson, therefore instructing Wakefield Quinn to pursue the appeal. And I would like the opportunity to defend the case on the merits. So,
Mr. Holtzman, he doesn't descend into any detail as to dates there, does he? Doesn't tell us when he became aware that of the time limit by which the application for leave to appeal should be filed. Doesn't tell us of the dates of his discussions with Mr. Richardson.
yes.
Doesn't help us very much.
Well, in my respectful submission, my lord, the delay was 6 weeks. We had been.
So what delay was 6 weeks?
Well, yes. I mean, well, it should be 5 weeks. It was filed 6 weeks from the date of the judgment. So obviously you get 1 week. It's normally 7 days from an interlocutory judgment, 6 weeks from a final judgment. Well,
I think you've got 14 days and then 7 days to file the notice of appeal after leave has been granted.
Yes, yes. But in this case, of course, no leave was granted.
Sorry,
but in
can we
terms
be
of-
clear about this? The judgment was given on the 6th of October.
Yes,
14 days from the 6th of October takes you to the 20th.
right, yes,
So the application for permission to appeal should have been filed on the 20th of
Yes.
October.
yes, ma'am.
And it was in fact filed on the 17th of November.
Yes. So 27, it was 27 days late.
Yes.
Yeah, if we're looking at the time frame in which the delay was. So I think we're all agreed that this application was filed 27 days late. And all I can say, and I don't want to give evidence in relation to my Lord Justice Bell's question, but there were discussions, and I was hopeful that a settlement might be reached. And when it went pear-shaped, then it was decided to file the appeal. You will note from my submissions, and my learned friend has made reference to my informal emails going back and forth, where I had indicated on I believe it was the 3rd of November, where it actually had the appeal filed and ready to go, including a letter to the registrar, and then hope resurrected itself, and we decided not to appeal. And then you will see from the emails, my learned friend has placed them in his submissions for the dates. So if
Sorry to interrupt you, Mr.
Yes.
Holtzman. I would just express that my friend has characterised those as informal conversations, and I don't intend to rely upon those at the hearing of the present appeal. There's a reason that they're not included in the respondent's skeleton argument for this appeal.
Okay, all right, thanks. In any event, my lord, we accept that the appeal was filed 27 days late, but we would ask you to take into account the explanation, and that was that we were trying to settle the case without the need to go to this appeal. Obviously, heading to.
Mr. Holtzman, there were two aspects of it, and despite Mr. McCosker's assistance there,
Yes.
there were two. The first matter was that your client, with or without your assistance, was seeking to settle with Mr. Richardson.
Yes.
And if he'd been able to do that, an appeal would have been moot.
Yes.
And the second matter was that in early November, on the 12th, by which time you had drafted an application,
Yes.
you had told him that you had been to see your client, and I'm looking at page 75 of the record, and you told him that it made little sense to proceed in the context of the amount in dispute. So there are two separate matters there.
Yes, they were. Well, and there was it was in the context of, on the one hand, we were, I don't want to get into too much discussions with my client. On one hand, we were looking to what we might be able to recover from a settlement with Mr. Richardson versus what would be in dispute. And I appreciate that they are two, and I see my informal emails are coming back into play in any event.
Yes.
But you are right, my lord. When I indicated to my friend, I was trying to avoid this appeal at all costs, given the amounts. It was hopeful, and it was with the amount, with potential settlement that we had coming from Mr. Richardson, and
Right.
the amount in dispute would have been not worth going to this court. In fact, we're all aware of the cost of proceeding on appeal, the cost ramifications, and certainly I was trying to avoid it at all costs. But so that is the reason for the delay in filing this application and the 27th. When my client wasn't satisfied, then I was instructed to appeal and to pursue it in this manner. My learned friend categorized it as an intentional act, and as I've said in my submissions, it was. As I indicated, we were trying to avoid this course at all means possible. But I would suggest to this honorable court that trying to avoid time, expense, and consistent with the overriding objective can amount to a reasonable and justifiable excuse.
But Mr. Horseman, you accept that the statement that's made at paragraph 21 of those submissions, page 77 of the record, that the delay was deliberate, not inadvertent?
Yes, I do. Yeah, I have to do that.
Yes.
Yeah, it wasn't a mistake. We had known the time had passed, and it was hoped that we wouldn't have to appeal. So it's interesting. I haven't been able to find a case where such a factual scenario has come before the court, where it was basically a tactical decision to not file the appeal in the hopes that we would in fact have a settlement, but when that went pear-shaped, then a decision was made that my client wanted to file the appeal. So so you've got the reasons for Mr. Richardson missing the deadline, having to do with his busy schedule, and then you've heard the reasons why the appeal in this court was not filed. So do your lordships have any further questions on those particular issues?
No,
Okay.
not for myself.
So I'm picking up on my submissions, my lord. Obviously, your lordships will be well aware of the factors that are normally taken into account, whether to grant an extension of time. And that's the length of delay, which in this case is 27 days. We would suggest that the delay is not inordinate. The reasons for the delay, obviously gone through those in detail with your lordships. And then the chances of the appeal succeeding if an extension is granted, along with the degree of prejudice to the respondent if leave is granted. And I think those provisions are all well known to your lordship. And if you turn it over to paragraph 8 of my submissions, my lord, you'll see I quoted from the white book, and which is at page 7 of the record. And where the delay in serving the notice of appeal is short, and there's acceptable excuse for it, an extension of time will not be refused on the basis of the merits of the intended appeal unless the appeal is hopeless. That comes from the case of Palada Investments Limited. And I will, of course, be upfront with the court that it's a different situation. In this case, in Palada, the case was a 3-day delay. There were new rules that had been implemented, and the council was confused about the rules. So there are different, obviously, so to say, better factors or factors more advantageous to the intended appellate. In that case, of course, the delay was very short, and the excuse was not familiar with the new rules. But if you go to, if I take your lordship to Palada, just the last paragraph, which I've referred to in my submissions, which is at page 17 of the bundle. And I'll just read it out. The whole of the matter, it seems to me, depends on whether or not we can properly look at the delay in this case as being an exceptional one. My judgment, I would so classify it. So they're saying that the delay here was an exceptional one. I've already referred to the shortness of the period involved, 3 days. I've also referred to the fact that the plaintiff's solicitors knew that there was in all likelihood to be an appeal. There was no question of their proceeding on the false assumption that they achieved finality for their client. I have referred to the fact that the solicitors asked specifically of the counsel for the statement of the length of time for serving notice. They gave a clear statement of the 6 weeks. There was the additional point, not content with that they checked. It was already mischance that the new edition of the Supreme practice arrived a few weeks later. It stopped them appreciating that the counsel was in error. There's no question of any prejudice arising to the plaintiffs in the circumstances which I've described, and in that situation, there was, in my judgment, absolutely no need to go into complex and time-consuming question whether or not there was a good case, good arguable case on the appeal. There was no invariable rule that requires such consideration. We obviously involved the very reverse to what the new procedure is designed to achieve on every application to extend time. There was a pre-appeal hearing in order to consider the prospects of success. I accept in this case, my lords, that you're going to have to look at the prospects of success in doing this. But I would suggest that in this case, it's a very difficult situation, very difficult. It can't easily be resolved on affidavit evidence. My client is saying, as you've seen, who's in the boat business, the T-top and the floor was fine, that it was appropriately secured. Mr. Sampson is saying it wasn't. This is a question of fact.
Mr. Horstman, your client's affidavit wasn't before the Chief Justice when he dealt with the application to set aside the default judgment, was it?
Pardon?
Your client's affidavit was not before the Chief Justice when he dealt with the set-aside application.
No, there was an affidavit before, my lord, and that was...
There was Mr. Richardson's affidavit before the Chief Justice.
Yes, my lord, that's correct.
Not your client's.
Yes, sorry, I'm thinking, I'm particularly thinking about the, sorry, I was mistaken, my lord. I was thinking about the leave to appeal application before the Chief Justice. There was an affidavit of Mr. DeSilva. You are correct. My client, unfortunately, he wasn't even aware of what the application was. He wasn't able to tell me what the application was. So when I went to court, I found out the day before that this was an application to set aside when I received Mr. Richardson's file the day before the hearing. But the answer is no. There was no affidavit from my client. Mr. Richardson had not sought to obtain one from him. So the only affidavit before the Chief Justice in in connection with that application was
Mr.
Mr.
Richardson.
Richardson's affidavit. You're absolutely right.
But as I understand it, there was at the hearing before the Chief Justice in August,
Yes,
two defences.
yes,
Is that right?
yes, that's correct. You'll see the Chief Justice refers to them both in the judgment.
Yes.
And you can see Mr. Richardson's defense, which is at page 52 of the record.
Yeah.
And in terms of the Chief Justice quoted the relevant parts of the defense there. And then there was additional defense that I drafted, which you'll find at pages 65 to 68 of the record. And the relevant parts being in paragraphs 14.
No, I don't have it there. Did you say 65?
Sorry, yeah, page 65, record of the appeal.
Yes. And that was before the Chief Justice, and he refers to it at paragraph 16 of his judgment on page 24 of the record.
Yes. And in terms of the crucial issue, that was at paragraphs 14 and 15, saved that at page 67, saved that it is admitted that Tyrone Sampson inspected the boat, identified as opinion works need to be done. Defendant denies that the boat is not seaworthy or fit. The boat is presently in the water, had no issues with the seaworthiness, withstood hurricane force winds while remaining in the water. Paragraph 1920 admitted the defendant denies the works outlined in the report were necessary in order to render the boat seaworthy. The boat was and is seaworthy. And I should pause there, my lord. I don't want to get bogged down in other detail, but this was a boat in Bermuda that was being imported and brought in for the cost of $15,000. The invoice said, listen, it's going to be in fair condition. And what happened is, and I think you should get the flavor from it in Mr. DeSilva's affidavit, but first they had to, the defendants wanted to, or the respondents wanted to put on their engine. A new tramson had to be built in order to accommodate that engine. Then there were additional, all new hatches, new stereo. They wanted to make the boat in a much sort of renew it in as best a possible way. And so this wasn't a case where a contract was for the purchase of a boat for $15,000 and my clients, the costs just were overruns as were categorized in the writ. But there were, and perhaps it might be helpful just to take you.
Well, I don't know where you're going to go, but can I take you to page 59 of the record?
Yes, my lord.
Which is a document headed purchase invoice.
Yes, my lord.
And it's got an invoice date of 5th of September 2019.
Yes, my lord.
Which is a curious date.
Yes.
And just so that we can see it, on the following page, page 60, there is an invoice of the same date, which deals with the rebuilding of the transom that you just referred to for an amount of $7,000. But going back to 59,
yes, my lord.
It said that the amount due is $15,000. Let us just note that apparently only $5,000 of that was paid on the due date, leaving a balance of $10,000.
Yes, my lord.
But it said below 20-foot center sole aquasport includes installation of 200 horsepower Yamaha.
Yes, my lord.
So the boat was equipped with a 200 horsepower Johnson Evinrude, which didn't work.
Yes,
So are we right to infer that the Yamaha is the engine belonging to the respondents?
that I did not know, my lord. I'm not sure.
Sorry?
I'm not sure off the top of my head.
Right.
I'm not
But
clear.
it does suggest that a different engine would be installed all as part of the 15,000.
Well, that would appear so on that particular invoice, whether you can
Yeah.
see.
Do we know why the invoice is dated 2019?
Whilst we grapple with that irritation, before, so far as the engine is concerned,
Yes, my lord.
and my lord has said at page 59, it says this includes an installation of a 200 horsepower Yamaha.
Yes,
If you go back to page 40, at paragraph 13, what is said by Mr. DeSilva is the first issue that occurred was the plaintiffs wanted their engine that they already owned, which was on another boat,
yes,
installed on the boat.
yes. I believe what happened, my lord, and this makes sense, is that the Evinrude on the engine was no good, and there was going to maybe be another engine put on, but at the respondents, I believe, decided that they wanted to put an existing engine that they already had on another boat, on this boat. And it was all agreed that the work for the transom had to be done. It was quoted along with the additional painting on the sides of the boat, which was not part of the original price. And so this was invoiced and it was agreed and it was paid. So,
Mr.
Well,
Horst,
hang on. When you say
we're on Mr. DeSilva's affidavit.
yes,
Some minutes ago, you said that it was before the Chief Justice on the leave application.
yes,
But if you look at page 42,
yes.
you will see that it was sworn on the 24th of December.
Yes, my lord. You need to
Order
go.
refusing leave.
The affidavit I'm referring to that was before the Chief Justice is at tab 13. It seems that they happened to get placed out of order.
Yes,
when
at
the
page,
record- yeah.
page 90, tab 13. there
Page
is the
90.
affidavit of- Sorry?
Yes, at page 90,
90.
you see.
There's the affidavit of the 14th of December, which was before the Chief Justice on the leave application, which was dismissed on the 17th.
Yes,
Thereafter, exactly the same affidavit was used, save, if you go back to
yes,
page 37, that it's now headed in the Court of Appeal and
Yes.
begins by saying, I am the intending appellant, rather than I am the defendant herein.
yes, because one of the first application is before the Supreme Court. So,
Yes, I follow that.
Yeah.
And confusingly, they have been put out of order.
Yes, no, exactly. They should have been switched around.
Yes.
I won't blame Mr. Coelho for that.
No.
Please,
I sometimes wonder whether it's just to see whether we're reading the papers.
No, yes, they've been switched around when the record of appeal was formed. So you'll see the affidavit at page 90 was the one before the Chief
but in
Justice.
any event, this is an affidavit which was not before the Chief Justice. We're agreed that all he had before him was Mr. Richardson's affidavit.
Absolutely, my lord, yes.
This is at the time of the
So,
application.
and I think when we're looking at this, you've got to compartmentalize the application for leave out of, the application to set aside the judgment back in, whatever it was, and then back in August, which was just the affidavit, Mr. Richardson, and then once the judgment came out, leave to.
Mr. Horstman seems to have frozen.
Have I frozen?
Not for me.
Nor for me.
You still have me?
Can you?
I could see and hear you.
Okay, right.
But wait a
Everybody-
moment, I think Justice Bell has frozen.
Yes, it's just,
Justice Bell, you're muted.
But you're unmuted now, Justice Bell.
Yep.
Okay.
Right. But can you help me on this? We discovered that the Chief Justice did not have Mr. DeSilva's December affidavit before him at the August hearing.
right,
And obviously he didn't have the later affidavit after he'd refused leave in December at the hearing in August.
right, correct.
The report from Mr. Sampson
Yes,
is exhibited to both of those affidavits.
yes,
What is not clear to me is whether at the hearing in August, the judge had before him Mr. Sampson's report.
yeah. Yes, he did have it.
He
Sorry.
did he? How do we know that? Because you
Well,
remember-
it's recited in the judgment, and
Now that's the point. It is undoubtedly recited in the judgment, and the judgment recites it effectively from the pleading.
yes,
It's not self-evident to me that the judge was doing anything other than set out in the judgment what the pleading said the report contained.
yeah. I see Mr. McCosker wants to say something.
If I may, my lords, my recollection of the matter is it was some time ago, but we attended court with material including some photographs of the vessel. Both Mr. Horseman and myself presented some photographs, and I believe that the report was handed up with those photographs at the time.
Right. Okay,
That's my
that's very
recollection.
Thank you.
Yes, I would concur with that, my lord.
Right. Thank you. Right.
So, my lord, we looked at the draft defense that I filed, and again, Mr. DeSilva's affidavit, where he took the bull by the horns, so to speak, in terms of denying and saying that the top was appropriately secured. So in my view, that was a triable issue in which my client should be permitted to defend. Aside from requiring him to go and file expert evidence at this stage, which is what the Chief Justice seemed to have raised the bar. And I understand the Chief Justice's point that only having Mr. Richardson's affidavit in front of him, he did have the draft defense.
Having whose affidavit?
Mr. Richardson's affidavit. Yes, I'm back to the August hearing. But he did have the draft defense that I put together, which we've just looked at. Unfortunately, as you might imagine, I had to ride with Mr. Richardson's affidavit, as I had one day to sort of review a substantial file of emails and documents, and then draft a defense, which I managed to get done prior to the hearing. The matter was put over for one day in order to allow me to get ready for this application. But I would say this to you, my lords, Mr. DeSilva has put a defense to the core issue, and it's my respectful submission. He should have been given leave to defend the matter. The judgment should have been set aside. And if we go back to the Chief Justice's judgment, and I will just say this in relation to Mr. Richardson's defense. He did say, listen, the boat is seaworthy and fit for use. He had to get that from somewhere, from instructions from my client, who does have some experience
Mr. Horseman, I don't think you're going to get very far with your suggestion that what Mr. Richardson was doing was giving evidence on behalf of your client.
Well, I think he was giving evidence on behalf of my client, but I take your point.
It wasn't your client's evidence. It was an assertion by Mr. Richardson without any basis upon which he might properly make that assertion.
Yes, well, except for that he must have taken instructions from my client at some point. But I take your point, my lord. I'm trying to say in my submissions that he would have had to have gotten those. I mean, it would be very, very, very unusual for a lawyer to make a positive assertion like that without having instructions with some basis to do so. I guess I could put it no higher than that in light of Richard's comment.
It's not evidence, is it?
No. Well, it's not ideal evidence.
It's not evidence at all.
Yeah. Fair enough, Malone. I take your point. But of course, not my client's fault, and so that was one of the reasons why my client felt hard done by and wants to defend this matter. This was no fault, as I think it's been accepted by everybody, that his defense was not put in on time. Mr. Richardson has clearly acknowledged that, and it's created this procedural tangle that we're now in. If I could just go to paragraph, actually, I'll take you to the judgment, my lord, if we could go back to it. That's at page 19 to 30 again. And I'm just looking at the Chief Justice citing the relevant test in paragraph 17 at page 24 of the record. And it's a little easier to read from the judgment than the white book. The purpose of the discretionary power is to avoid the injustice which might be caused if just judgment follows automatically on default. The primary consideration in exercising the discretion is whether the defendant has merits to which the court should pay heed, not as a rule of law, but as a matter of common sense. If there is no point setting aside a judgment if the defendant has no defense, and because if the defendant can show merits, the court will not prima facie desire to let a judgment pass in which there's been no proper adjudication. My lord, I appreciate, in light of your lordship's comments on Mr. Richardson's affidavit, but I would suggest that now that you have Mr. DeSilva's affidavit, and I appreciate that if we're appealing the Chief Justice's judgment, you have to consider what was before him at the time. But I would think in taking a holistic view of the hardship encountered by my client, that this court could consider my client's affidavit and the reasons he's put forward. So as to avoid, as the white book says, not to let a judgment pass when there's been no proper adjudication. And I'll just carry on down. It's not sufficient to show merely an arguable defense that would justify leave. It must have a real prospect of success and carry some degree of conviction. Thus, the court must form a provisional view of the probable outcome of the action. If proceedings are deliberately ignored, this conduct of no amount of estoppel must be considered injustice for exercising the court's discretion to set aside. The editors of the Supreme Court go on to state preferred view that unless potentially credible affidavit evidence demonstrates a real likelihood that the defendant will see on the fact that no real prospect of success is shown, and relief should be refused. It's if your lordship is of the view that there's no evidence in Mr. Richardson's affidavit, I would say that the court, the Chief Justice, should or could have had recourse to the defense filed by myself put before, although not affidavit evidence. And that's the reason it was a defense on the merits, and one which the court could pay heed, if not attached to an affidavit. And that was the reason I put into the case bundle the Bermuda Court of Appeal of Tucker and Tees, Kemper versus Tucker, sorry.
In what way, Mr. Horseman, do you say the Chief Justice did not have recourse to the defense?
Well, as you can see, my lord, he's plainly just referred to, well, he's referred to the defense, but he's basically referred to Mr. Richardson not providing affidavit evidence. I mean, if you look at the judgment, and we can, if we go to pages, paragraphs 21, let's see. Yeah, we can take it from paragraph 23. The only affidavit evidence filed in support of the application to set aside the judgment is the affidavit of Mr. Richardson, the defendant's former attorney. Mr. Richardson deals with this issue in paragraph 13 of his affidavit, where he plainly stated the salient issue of this matter appears to be whether the boat is structurally sound and fit for recreational use in Bermuda's harbor and littoral waters. Respectfully, the facts of the matter demonstrate the boat is clearly fit and sound for these purposes. Mr. Richardson does not state he has any particular qualifications to express his opinion. Furthermore, the affidavit makes no attempt to expressly deal with the serious allegation that the fact that the cockpit sole becoming delaminated made it possible to permanently secure the center console to the hull of the boat. Mr. Richardson in his affidavit seeks to draw a distinction between two issues: whether the vessel was in condition that was capable of being insured, except that it was not, and whether the vessel was in such a condition that it was seaworthy. He asserts that it was. It's not readily apparent why a vessel which was seaworthy should not be a good risk for a purpose of insurance. In any event, no distinction is exerted in the draft defense settled by Wakefield Quinn. In the circumstances, I'm not satisfied the defendant has filed credible affidavit evidence, therefore demonstrating a real likelihood that the defendant has a real prospect of success. In my judgment, the defendant failed to discharge the burden of proof which rests upon him to establish he has a real prospect of success. So,
But isn't that the nub of it, Mr. Horseman?
yes. Well, I mean, plainly in that part, my lord, he's nailing his colors to the mast when we say he's failed to discharge the burden, by relation particularly to the credible affidavit evidence, by not filing any credible affidavit evidence. And typically in past, I've had in the past filing defenses and putting a defense before the court considers the defense and whether a defense is asserted on it.
Mr. Horseman, the normal practice is for there to be an affidavit which speaks to the merits, and
yes.
that is normally done by exhibiting the defense
Yes.
and making averments in relation to the prospects of success of that defense.
Yes.
Granted, you had very little time, but that wasn't done here.
Yes, that's correct. But that's what I asked the court to take into account. That we had very little time, and I was picking up, Mr. Richardson, as you can see from the email that was exhibited to Mr. DeSilva's affidavit. The day it gave him advice that he had no case and was basically throwing his hands up, and that's what Mr. DeSilva came to me, and I can tell you it was an all-nighter going through volume of emails and invoices dating back, which spread over a considerable period of time.
What is it about the defense that you say goes to the merits, which the Chief Justice did not consider?
This is the paragraph. I recited him in my submissions, but I'll take you to the middle. So you will find it at page, well, these were the two paragraphs that were cited, paragraphs 14 and 15, which is at page 67 of the record. And as he said, that admitted that Tyrone Sampson inspected the boat, identified his works needed to be done. The defendant denies that the boat was not seaworthy or fit as alleged to it all. The boat is presently in water, had no issues with seaworthiness, withstood hurricane force. Paragraphs 19 and 20 are admitted. The defendant denies that the works outlined were necessary in order to render the boat seaworthy. The boat was and is seaworthy. And then, of course, you have that's supported by Mr. DeSilva's affidavit, where he's saying the top was already secure, but in light of this report that was out there, he went and still went ahead and reinforced the floor in any event.
You put in a new floor.
Yes. Yeah. And I mean, just to look at Kemper and Tucker, my lord. Which is at tab 5 of the authorities. And of course, this was a Bermuda.
What page of the?
Sorry, page 20 of the record, my lord.
Thank you.
I think you could pick it up in paragraph 5 at page 21. Basically, this was a claim for repayment. We are not concerned with the first action.
I'm so sorry, what are we looking at?
Kemper versus Tucker,
Oh,
the Bermuda Court of Appeal case.
yes.
Yes, we'll pick it up from paragraph 4. There are 2 actions pending which are closely related by reason of the parties involved. The first is action number 102 of 199, in which Tucker Steves Bermuda is seeking to enforce certain claims against Eric Kemper, trading as Eric's arcade place, under an agreement made between them. The second action is 103, in which Mr. Harry Scott Tucker, president of Tucker Steves Bermuda Limited, is seeking repayments of money which he claims were loaned to Mr. Kemper, trading as Eric's arcade place, Flying Dutchman. We're not concerned with the first action, and I say relatively little about it. As for the second action is concerned, Mr. Kemper failed to enter an appearance, and judgment was entered in default. An application was made to set aside the judgment. The application came before Justice Ward on the 25th of July, who refused the application on the ground defendant are not satisfied and there was an arguable or tribal issue. An application was made on the 6th of August 1991 for leave to appeal against the decision of the learned judge. On the 22nd of August 1991, the application for leave was refused by Justice Ward. And the next appears an affidavit sworn on the 5th of October by Mr. Delroy Duncan, purporting to support an application which allegedly made by the defendant on the 13th December 1991 for an extension of time in which to make an application for leave to appeal. The application is not, the 13th September itself is not in the record. In due course, the matter came before us. After considering the relevant matters, the extension of time was granted. Leave was granted to pursue a motion dated the 12th of September 1991 to appeal the decision refusing leave, and the court decided to treat the application for leave as the substantive hearing of the appeal, refusing to set aside the judgment and in default of defense. in approaching this issue, one bears in mind the salutary admonition of Lord Atkins in essence versus Bartlam. The principle is that until a court has pronounced a judgment on the merits by consent, it is to have power to revoke the expression of this coercive power, whereas what has only been obtained by a failure to follow any rules of procedure. In deciding whether to deciding whether to exercise its power to revoke, the court decides whether the defendant has disclosed a triable or arguable issue. Indeed, has been said by the editors of the White Book, an application to set aside the default judgment, the major consideration, whether the defendant has disclosed a defense on the merits. And they go through the facts. Let's carry on with it. Turning now to the incident case, we find the following facts alleged in the proposed defense. Mr. Kemper owned the shop, the Flying Dutchman Boutique, where he'd done business for 20 years. He was on the verge of disposing of the shop to the First Bite Computer Company at the price of $75,000. Unfortunately, Mr. Kemper, he was somewhat in arrears with his rent. The scenario continues. Enter Mr. Harry Tucker, President and Director of Tucker's Tees Bermuda, as agent for the company, puts forward the proposition: forgo your sale of the shop, enter into agreement with Tucker Tees, where you will sell the company goods as exclusive retail distributor. Improvements to the shop and its image would be made at the company's expense. In return, the company would advance Mr. Kemper such sums as were necessary to satisfy his arrears of rent. The proposed defense states, it's expressly agreed that this payment was to be made in consideration of the promise by the defendant to forego the sale of the shop and to permit the sale of the shop as aforesaid, but be limited on an exclusive basis. And then comes the assertion: pursuant to the agreement, the plaintiff acting as servant or agent sent Tucker's Tees, paid to the defendant the sum of $11,000, $11,280, partial satisfaction of the defendant's arrears of rent. The defendant honored and complied with all the terms of the agreement. The defendant then concludes by denying liability. If matters rested here, the case would present little difficulty. There is, however, an affidavit of Mr. Scott Tucker sworn the action to which reference is made to above. Paragraph 6, he disposes the fact he was informed by Mr. Walker, Mr. Kemper's former landlord, that Mr. Kemper was rented his shop on a month-to-month basis. The fact that the evidence remains uncontradicted. It does seem unusual any purchaser would wish to purchase $75,000 for a lease, which could be determined by a month's notice, but the world of business is strange. Mr. Kemper would call benevolent purchaser at trial. He would perforce have an arguable defense indeed. This is not a course of trial. It takes the view not for us to determine the issue on the evidence. In those circumstances, somewhat reluctantly, we decided there was a triable issue. So I think, my lord, as you point out, there was an affidavit that clarified issues, but you can see the court plainly took into account the defense before it considered it, whether it applied the defense. Now, bearing in mind the time difficulties we're in, I would suggest to lordships that the Chief Justice could and should have had recourse to the draft defense before it.
But Mr. Horstman, in your case,
yes,
the issue is whether the boat was seaworthy.
yes,
Your defense says in bold terms at paragraph 15, the boat was and is seaworthy.
yeah.
But without more, is there anything for this court to rely on? Because there's nothing that supports, nothing in terms of evidence which supports that bold assertion.
Well, there is the affidavit of Mr. Sean DeSilva, but again, that was not.
No, that's not.
Yes, but that was not before the Chief Justice.
And the only affidavit was Mr. Richardson, and there's no evidence that he was qualified to express a view.
Yes, absolutely, my lord. Yeah. No, I have to accept that, and
You did mention the paragraphs from the defense, the draft defense. What do you make of that?
Sorry, pardon?
You referred earlier to paragraphs 14 and 15 of the draft defense.
Yes.
What do you make of that in respect of the issue of seaworthiness?
Well, I mean, it was a positive assertion that the boat wasn't as seaworthy, and it specifically says these works were not necessary in the circumstances. You know, I'm not sure, you know, could the defense have gone further, but clearly, you know, it makes a positive assertion that the works were not necessary to render the boat seaworthy, which is exactly what Mr. DeSilva has said in his affidavit.
But the Chief Justice had Mr. Sampson's report, which says cockpit sole is compromised, core delaminated, made the sole very soft. The T-top and center console cannot be permanently secured down. And at the bottom of his remarks, it's not a good marine risk in its present condition. He was obviously concerned at the fact that the T-top and center console couldn't be permanently secured.
Yes, yes, madam.
And the Chief Justice seems to have taken that concern on board.
Yes, no, without a doubt, my lord.
And there's nothing,
You know,
nothing in terms
there were several things in the report that were being alleged that made the boat seaworthy, but the Chief Justice obviously latched on to what we would say, and I think it's a common ground between my learned friend, myself, the primary point that there was allegation by Mr. Sampson that this the top of the boat could not be permanently secured to the floor.
What I'm not clear about is whether it's your client's case that the remedial work done to the floor
Yes.
secure the T-top and the center console.
Well, but
have been done subsequent to the Sampson inspection.
yes,
In such a way as to make the boat seaworthy and acceptable, should have been accepted by the respondents.
well, as you can see, my lord, from his affidavit, he says that the work was not necessary, but nevertheless, you know, when they went, now that this report was out there and this whole dispute had arisen, that he went ahead and reinforced.
Will we just look at the timing of that?
Yes.
If we go, I mean, the boat was arrived, as I understand it, in Bermuda in September 2018. And Mr. Sampson did his inspection on the 25th of September 2019. Is that right?
no,
Yeah.
no.
The 9th of May.
No, the 9th of May, sorry, it's English. Right. But if you go back to page 41 of the record of, well, start with page 40. In the paragraphs which begin from paragraph 13 onwards,
Yes.
Mr. DeSilva sets out various things that were done. New transom in paragraph 13, spray the entire boat in 14, and there's a quote in 16.
Yes.
Then in 17, agreed new transom and painting. 18, they agreed to pay an additional 8,000. Then 19, the stereo. Then he says in 21, when the boat came up for delivery, they had it inspected, and the main point of contention was the sole of the boat being delaminated to the point where Mrs. Sampson said the T-top could not be permanently secured. As indicated above, not sure where that is, I corrected that deficiency for 3,895, and in my view, at best, the court could have awarded damages in that amount in order to correct the issue. So presumably the work referred to in paragraph 21 is done after the 9th of May.
Yes.
19.
My lord, may want to look at paragraph 9 of the affidavit in that regard.
Yeah, and that's the above paragraph referred to.
Yeah.
All right.
But in answer to your question, my lord
The
President,
reason why I mention that is because it's suggesting there that it had already been done.
no, I don't think he is, my lord.
Oh.
But I mean, it's clear in paragraph 9 that he went out and did it after the report, and after they had refused delivery.
Yeah.
So what happens is, Mr. Sampson says in May 19 that it has these defects.
Yes.
After May 19, Mr. DeSilva carries out various improvements by installing a new fiberglass floor, and says that after he'd done that, it was perfectly capable of withstanding a hurricane. See the picture. We don't quite know when that date is, but presumably it's sometime not long after the 9th of May. And the writ is issued. The writ is issued on the 7th of November. Excuse me a moment. Hello. No. Right. So what appears to be being said is, A, it wasn't unseaworthy. B, when I saw the report, I did everything that was necessary to make it better, if it needed to be made better, as a result of which it was perfectly capable of withstanding a hurricane.
Yes. Yes.
And all that before the proceedings were issued.
Yes, that's correct, my lord. They were corrected before the proceedings, but I think at that point that Mr. Heyrana and Mr. Gibbons were not interested in the boat anymore. And it sort of, there was an agreement between them for Mr. DeSilva to go on and keep the boat, and they refused delivery. I should be careful. But then they entered an agreement saying that, listen, you go sell it, and then.
This is all after the event, Mr. Horseman.
Well, no, listen, my lord. Yes, I'm just giving you background, but yes, it is after the event.
Well, yes, the agreement about selling it is all after the event.
Yes.
The work done, which cost $3,895, is in a sense before the event, if you're saying that the event is the issue of the writ.
Yeah, yes.
Well, we don't know when that was, do we?
We don't, but one might infer that it's unlikely to be, if he was going to do it in May, unlikely that he waited until November.
Problem is that isn't at all apparent from paragraphs 14 and 15 of the defense.
Yeah.
There's no affidavit evidence before the Chief Justice at the time to explain it.
That's correct, my lord.
At the time of the argument before the Chief Justice, there was no evidence that the problem identified by Mr. Sampson had been or could be corrected.
No, there wasn't. Not that I'm aware of. But there is evidence before your lordships.
Yes.
I suppose you'll say that with the time available to you, you weren't able to present that affidavit evidence. Is that it?
Well, that's correct, my lord. Unfortunately, I had to, and looking back in hindsight, I probably should have fought tooth and nail for a longer adjournment, but it was made very clear. I was hoping that this was a mention in the normal Thursday's chambers, but it was brought to my attention that this was in fact a substantive hearing, and that changing counsel was not going to be seen as a delaying tactic, and the matter was set down the following day.
Yes.
So, my lord, the only other point that I would make in relation to, I know my friend has lots of case law, and I don't think I disagree with a lot of it, but the Chief Justice plainly, and I'd just like to take you to the judgment and the reason for the default. And deal with this case that the Chief Justice relied on. No doubt my lord in front will be taken into. In paragraph 26, And that's at page 28 of the record, my lords.
Right.
Yeah, Mr. McCosker appears for the plaintiffs, argues that the court is entitled to look at the defendant's conduct statements ascertained in the circumstance in which it disentitle him from proceeding. In this regard, he relies upon the recent English cases, which have made it clear that attorneys' failure to properly prioritize between competing client interests will not amount to a good reason to set aside a judgment default. Particularly, he relies upon the decision of the English Court of Appeal in Mitchell versus News Group Papers, where the court stated, if the non-compliance cannot be characterized as trivial, then the burden is on the defaulting party to persuade the court to grant relief. The court would want to consider why the default occurred. If there's good reason for it, the court will likely decide that the relief should be granted. If, for example, if the reason why the document was not filed with the court was that the party or solicitor suffered from a debilitating illness or was involved in an accident, then depending on the circumstances that may constitute a good reason. But merely overlooking deadlines, whether on account of overwork or otherwise, is unlikely to be a good reason. We understand solicitors may be under pressure, have too much work. It may be that this is what occurred in the present case, but that would rarely be a good reason. Solicitors cannot take on too much work, expect to be able to persuade a court that that is a good reason for their failure to do so. And I don't think, and my lord, I just wanted to take you to that case because of my respect for the submission. That case was under the new CPR rules, in which there had been what's called the new Jackson report, in which case there was a very stringent new guidelines being put in place that, and I just want to highlight it to you for your lordship, because I think in my view, the learned Chief Justice, relying on Mitchell, took much too harsh of a view of Mr. Richardson's default, particularly in light of the, it's no doubt that he should have had it in time, particularly given Mr. McCoster's notification to him that he would apply. But in looking at Mitchell, which you will see you'll find at page, starts at page 47 of the Joint Authorities Bundle. And I just note at the bottom of page 47, I mean, just to give you the background really quick, this is a case where you had to file a budget of costs within 7 days, and the solicitor in this case missed the deadline. And you'll see at the bottom of page 47, just in sort of the head note, that this is guidance on the new, more robust approach to the court's enforcement of compliance with rules, practice, and directions of court orders, see paragraphs 40, 46. And if I could take you to page 58, in paragraph 41, you will see, I'm just highlighting, that is the paragraph that the learned Chief Justice relied on in the judgment. And I would just highlight at page 59, paragraph 46.
Just a minute. Do you want us to just make a note of paragraph 41 and we'll go back to it?
Well, I don't think we've just read it, my lord. So I'm just pointing out where the Chief Justice got it from.
Right.
Yeah, and what I would ask you to do is to turn it to page 59 and we'll pick it up in paragraphs 45. And these are the new CPR rules, and it just says in paragraph 45, on an application for relief from a sanction, therefore the starting point should be that the sanction has been properly imposed and complies with the overriding objective, that the application for relief is combined with an application to vary or revoke, and that should be considered first and the Tibbles criteria applied. But no application made is not open to complaint that the order should not be made, whether on grounds that did not comply with the overriding objective, whether the reason. Actually, I can take you down to 46 because it describes generally the new, more robust approach that we have outlined above will mean that from now on, relief from sanctions should be granted more sparingly than previously. There'll be some lawyers who have conducted litigation in the belief that what Sir Rupert Jackson described as the culture of delay and non-compliance will continue despite the introduction of the Jackson reforms. But the implementation lectures given well before 1st April were widely publicized. No lawyer should have been any doubt what was coming. We accept the changes to the litigation culture will not occur overnight, but we believe that this is likely to be given too long. And so,
Chief
there
Justice,
was
Mr. Horstman,
yes,
the Chief Justice sought to essentially get that in through the overriding objective.
he did.
Yeah.
But what I would say is these particular rules to the CPR, well, I would just say are more stringent than our overriding objective. But you're absolutely right, my lord. We do have the overriding objective, and don't get me wrong. But I would suggest that we're not at where the CPR rules are in terms of which have been adopted following the Jackson report into the UK. And it is a much more stringent approach. And I'm not aware of any Jackson report being provided in Bermuda. And I would just say, and listen, I'm not suggesting to this court that rules are meant to be broken. But I am suggesting, the white book, in fact, talks about a solicitor's mistake. What I would call, under the old approach, inadvertent is in fact a rule. If you were to go back to page 7, albeit it is a 1939 case cited, but I'll just read it out for you. And extend page 7 of the record. It's just the white book commentary.
Yes.
Not of the record, of the joint authorities.
Yes.
It says an extension of time can be granted in appropriate circumstances, even though the failure to appeal in time was due to a mistake on the part of a legal advisor. And that would be, I would say that that's applicable in terms of missing out filing a judgment time. I mean, in my respectful submission, I think Mr. Richardson, although he's given Mr. McCoster's express notice to him, there's no real excuse for not getting defense on time. Although being involved in a murder trial, I'm sure your lordships will be aware of the stress and how it overtakes your complete life, having done one or two myself. Clearly, it was a breach of his contractual duty to my client. One would consider, I would say that the Chief Justice was maybe being a little harsh on it, but and relying on the Mitchell case. The Chief Justice does note that these are requirements of the CPR rules, but as my Lord Bell has pointed out, we do have the overriding objective, but I'd suggest that Mitchell adopts a much harsher approach than we would here, particularly considering the length of time involved. So, my Lord, those are my submissions. I think your Lordship has the issues. I mean, my client is desperate to defend the case on the merits, rather than having to go take Mr. Richardson and then have to have the chances of his winning that case be dependent upon his loss of opportunity to defend this case in assessing damages. So you ask you.
Thank you very much. Shall we take a 10-minute break now?
Yeah, sorry, Mr. Justice.
So sorry, do any of my colleagues have any questions?
Yes, I just had one, and for some reason I found I got myself muted. The draft defence that you filed, Mr. Horstman, page 66, paragraph 10, denies paragraph 13 of the statement of claim, which is the claim that there were significant cost overruns when compared with the all-inclusive cost of $15,000. And
yes.
your pleading says there were not significant cost overruns, as alleged or at all. Well, a total of $39,000 paid when compared with a $15,000 all-inclusive cost does seem rather significant, doesn't it?
No, my lord, that's why you need to look at the affidavit. I mean, there wasn't a new stereo included with $15,000, and they decided they wanted to make the boat as new. So, they wanted to respray the boat, put all new hatches, so that was,
What did all-inclusive mean?
well, in the context of a $15,000 boat, it didn't mean a brand new boat, which is what the respondents were now seeking to do.
All right.
Right.
And it was also subject to price change. But thank you, my lord. Shall we take a break then?
We'll take a 10-minute break.
I'm grateful, my lord.
Let's say 10:35.
Thank you.
Yes. Yes. Do we have a breakout?
Yeah. I think we could just leave and go over to the breakout room.
Yeah, but if we leave,
I don't see.
No,
the
don't
prompt.
leave the meeting.
no.
Mhm. There's no prompt for a breakout room.
Where there is a thing for breakout room. Should I click breakout room?
Yes.
Where is it?
It's
I don't see it yet.
Yes,
It's
yes,
to the very bottom.
yes.
Join breakout room. Yes.
I see you're dressed appropriately now, Ben.
Yes. I was under the impression that we were robing still.
Yeah, I know that. Yeah, the Court of Appeal are pretty relaxed in the Zoom contact. So
I'm an advocate of that.
yeah, exactly. I was worried when I saw you.
I must say I can't seem to get it right. The last appellate one. No, it was when we were doing trial work in the Supreme Court last year, and there was still confusion as to who's robing and who's not. But maybe next time.
Yeah. Hopefully, this shouldn't be an all-day affair. I don't think.
I anticipate. So it's what 35 past. I wouldn't imagine I'll be more than 30 minutes.
Yeah.
And then if you want to reply, hopefully the
I think the only thing I really needed to apply was on that Mitchell case. I don't think there's any dispute on the law. And I think they've taken on board sort of the points in dispute. And
I should just say that we're live on YouTube.
Yeah. Okay.
Right.
Yes.
Okay.
Good morning, my lords.
Thank you.
If I may, just to assist the court with its scheduling, I anticipate that my submission should run for no more than half an hour this morning, just in case you're trying to plan your afternoon.
I think the president is trying to speak, but he's muted.
And I think Justice of Appeal Smelly may be muted too.
Yes.
Yeah.
Sorry. Am I on mute now?
Yes.
No.
Thank you for that information. That's very helpful.
Thank you. So I don't think I need to rehearse the full extent of the factual background. It's in the record, and my friend has addressed it in his submissions. What I might do is spend 2 minutes just framing where this began and how we came to be before your lordships in March of 2021. So again, this dispute arises out of a contract that was struck in September of 2018 for the purchase of a vessel. The vessel was to be imported, and critically, and this is at page 3 of the record of appeal, which is the plaintiff's specially endorsed writ of summons.
Well, just a minute, Mr. McCosker, in paragraph 6, you say that the contract is evidenced by a series of email and WhatsApp exchanges between 27 August 2018 and around 30 September 2019. Is that?
It's a poor pleading, my lord, to be quite clear. The contract is based on an exchange of emails and WhatsApp messages, but they certainly don't extend to 30 September 2019. It is what the pleading says. It's a poor pleading, which I drafted. Essentially, the contract was struck by email and WhatsApp exchanges. Those documents make clear what the fundamental terms of the contract are. But an important component of the contract is what we've defined in the statement of claim as the capital R remedial work. That appears at paragraph 7.
Yep.
The vessel would be procured, it would be imported, and the appellant, the intending appellant, would attend to certain matters, cleaning the hull, maintenance, engine mounting, to ensure the vessel was safe and seaworthy at handover.
You take us quickly through the email and WhatsApp exchanges, which condense for those pleadings.
My lord, yes, Appeal Judge Smelly. The way that this proceeding has transpired is, as you'll be aware, the default judgment was entered, and an application to set aside that default judgment proceeded on the evidence of Charles Richardson. At the hearing before Chief Justice Hagen, certain documents were handed up, but as the recipient of a judgment in default, the respondents did not file under cover of affidavit the evidence which evidences the contract, not wanting to exceed to get into a substantive dispute about it, really. So I'm afraid to say, Appeal Justice Smelly, that I cannot take you to those WhatsApp exchanges at this time.
Right. So they are not the exchanges at pages 60, 59 to 63 of the bundle of the record.
There are some of the constituent documents which ground the contract have been exhibited to, I believe this is Mr. DeSilva's affidavit. That's correct. It's not the entirety of the contract.
I see.
But so what I had, subject to your lordship's view, what I'd intended to do is speak by reference to the pleading and the defence.
Right.
Right.
So the vessel was imported. The capital R remedial work was to be undertaken. Fast forward to May of 2019, some 9 months later, and the intending appellant is representing that the boat is ready, the remedial work has been undertaken, it's ready to be delivered. At that time, the report of Mr. Sampson was obtained, and as your lordships will appreciate it disclosed serious defects with the vessel which went to its seaworthiness. The core defect was that and I'm not a nautical person, I'm afraid, but the cockpit sole had delaminated, which effectively means you can have the best hull in the world, painted nicely, waxed and sheened, but if you can't fix the seats, the center console, the roof onto the boat, it's not going to be very, very good to use in the water. That was the primary defect that Mr. Sampson identified. Other defects in the context of seaworthiness included the water tightness of the bilge. That's an allegation that appears at page 5 of the record. And that because of, as a result of the soft cockpit sole, there would essentially have to be extra pumps installed together with redundant water supplies to ensure that the boat doesn't sink. This is how I read Mr. Sampson's report. What happened at this stage, and this is important to note because it's something that my friend has addressed you on.
Could you just,
Yeah.
I hadn't picked that up. So at page 57, Mr. Sampson says that the delaminated core has made the sole very soft. The T-top and the center console cannot be permanently secured down. I don't see any consequences flowing from that which might make the boat liable to sink.
Yes, so and this is by no means an opinion that I'm giving. The way that I read, above at page 57 of the record, above the underlined capitalized word remarks, there are 2 sentences. Due to the low laying waterline and cockpit sole, a second pump should be employed connected to a separate battery. This may give it added bilge water level control. Perhaps I've overstated it, my lord, but the issues were that the cockpit sole was compromised, the hull scupper is not approved, the bilge access is not watertight, fuel hose is deteriorated. These appear to be items which go to the seaworthiness.
Right.
What
you never use it, those 2 words, one word, the seaworthiness word, does he? And
it does not appear.
And the Chief Justice seems to take the view that if the true position is that the center console can't be permanently secured, it would accord with common sense that the vessel would not be seaworthy.
That is the finding that he made, yes.
Is he entitled to make that finding?
Well, if we think about the exercise that the Chief Justice was required to undertake at an application to set aside a default judgment, he's not expected to undertake a mini trial. He's expected to weigh the evidence before him and determine whether there is a real prospect of a success. Now, as I don't need to explain to your lordships, but that's more than a fanciful prospect. He is entitled to weigh the evidence. The evidence before him was a report of a qualified marine surveyor on the one hand, and an affidavit of a former attorney on the other, which from recollection said the facts are clear that the vessel is seaworthy. So yes. I think what his lordship did is he weighed the evidence before him in my submission appropriately.
Well, I wonder whether it could be said that he, not being an expert, took upon himself the role of an expert by saying that the defects complained of made the vessel unseaworthy, which, as my lord has observed, is not actually stated in the report of Mr. Sampson.
I think the only assistance that I can offer to your lordships is that the concept of seaworthiness is certainly not something that Mr. Sampson addressed. What Mr. Sampson said is that you can't connect the top of the boat to the bottom. And the Chief Justice, as a matter of common sense,
it's not a good marine risk in its present condition.
Well, to be perfectly frank, Appeal Justice Clark, I don't want the concept of a marine risk. Some would read that as an insurance risk. That's
Yes.
not how my clients read it. They read it as, is it a good boat to take out on the water? Marine risk and insurance.
Seaworthiness related.
Yes, so I certainly don't rely on that as an insurance term, but that's how I read it.
Yeah.
As a layman.
Yes.
When it comes to vessels. But it's important to keep in mind what happened after the report was delivered. At page 6 of the record, I would take your lordships to paragraph 20. What happened at this stage is the respondents to this appeal said to the intending appellant, our expert says this vessel isn't seaworthy. The photographs which were before the judge at the time, which are not before you, appeared to me to have the boat laying a little low in the water. And they said, you've breached the terms of our contract. Please fix this. Please give us a seaworthy vessel. And the intending appellant's response, which is set out at paragraph 20 of the statement of claim, is that he would not undertake any remedial work unless the respondents paid a further sum of $10,000 US. And importantly, even in my friend's amended defense, that allegation is admitted. Now, what we know, it's at paragraph 13 of, and this was not before the Chief Justice, it's what's come out later. It's at paragraph 13 of the defense, which was prepared by my friend, Mr. Horseman.
Page 67.
Sorry, paragraph 50, page 67 of the record of appeal, at paragraph 15. It admits that the sum of $10,000 was demanded, but then simply says that the remedial work wasn't necessary. Yet we know now, only after Mr. DeSilva's affidavit was filed, that he did undertake the remedial work. And what he did then was he sold the boat and kept the proceeds. That's really all I wanted to say in terms of setting the scene about how we got into this litigation. And subject to any questions that your lordships may have on that, what I intended to do is turn first to what happened, what was actually before the Chief Justice at that application to set aside the default judgment.
Could you just help me on something which may be a particularly stupid question? But if we look first at page 57 of the record of appeal,
Yes.
The critical sentence is that the T-top and center console cannot be permanently secured down.
Yes.
If we go to page 64 of the record of appeal, we see some footage of vessels in a hurricane. Which of those three vessels is the one we're concerned with?
None of them.
None of them.
No, it's almost impossible to make out, but
Perhaps my friend can assist, but I had the same question. I know what the vessel looks like from the photographs at the Supreme Court. I can't actually see it in this picture.
No, right, okay, well then.
One thing that from my limited marine knowledge I can positively state is that none of the three vessels that is clearly seen is an aquasport with a center console.
Well, that's appeared to me to be the position, hence my question.
Yes, those are
Perhaps if I can assist, you can see it right in between the two sailboats, although it's difficult to see it as copied. back
Barely
there.
visible.
Yes, but it's performing admirably in hurricane force.
I don't set much store by that, Mr. Horseman. We have no idea what the conditions were like in at this point, but
Right,
So-
okay, thank you.
So in a situation where the intending appellant was demanding another $10,000 to fix what the marine surveyor said was a serious issue, the respondents were forced to commence proceedings, which they did in November of 2019. Proceedings were served, some 30 odd days elapsed, and from what I understand, what the intending appellant's former counsel, Mr. Richardson, had done is he had filed, although not served on me, a notice of appearance, but he had not filed or served a defense. So on the 20th of January 2020, I was instructed to write to Mr. Richardson in accordance with our Bar Association rules. I hadn't actually, and I should, for completeness, the only way that I knew that Mr. Richardson was representing the intending appellant is by making my own inquiries with the registry, because I still had not been served a notice of appearance. But because I was aware that the intending appellant may be represented, I found out who he was represented by, and I wrote to him and put him on notice that the defense was seriously overdue and gave 4 clear days notice that my clients would be seeking to enter a default judgment. As we all know, no response was received. I was subsequently instructed to enter that default judgment, and that was granted on the 18th of February 2020.
Right.
We come before the court on Mr. Richardson's summons, dated the 6th of March, and the issues which were before the Chief Justice are: one, is there a defence with a realistic prospect of success? And 2, are there good reasons for the default? Now, dealing perhaps with the latter of those reasons, is there a good reason for the default judgment, why the defence was not filed? My friend took you to the case of Andrew Mitchell and News Group Newspapers Limited, and I think from what I can discern, the submission was that, well, that case was a product of the Jackson reforms. It's based on the CPR. Attorneys in Bermuda shouldn't be held to such a high standard. And I think this is President Clark's point, but I'll adopt it, is that the relevant provision of the CPR, which the Chief Justice was having reference to and which was dealt with in the Andrew Mitchell and News Group case, was CPR 3.9, which is broadly a direct equivalent of Order 1A of our Rules of Supreme Court. So CPR 3.9, I have in front of me page 29 of the record, my lords. This is from the Chief Justice's ruling. CPR 3.9 materially speaks of the need to conduct litigation efficiently and at proportionate cost, and to enforce compliance with rules, practice, directions, and orders. That could be contrasted with our Bermuda equivalent in Order 1A, which is to secure the just and expeditious and cheap resolution of disputes.
We don't have Order 1A actually shown anywhere, do we?
Yes, I believe it is not in your bundle, my lords.
Right.
But I can. I guess the.
No, I should be able to find it.
Yes.
My question was whether it was in the bundle, that's all.
Yes. From memory, it speaks of the just and expeditious resolution of proceedings. Now,
those are the overriding objectives, are they?
Yes.
yes. So the Chief Justice found, largely by reference to the Andrew Mitchell and News Group case, that for an attorney, it's not enough to merely overlook a deadline, whether you're overworked or not. There will rarely be a good reason, and this is at page 29 of the record. There's an extract from that case, which the Chief Justice had taken it upon himself to place in bold. Solicitors cannot take on too much work and expect to be able to persuade a court that is a good reason for their failure to meet deadlines. So, having considered the Andrew Mitchell case and having taken it upon himself to identify that yes, that case was dealt with under the CPR, which is not in force in Bermuda, but those principles are broadly equivalent with RSC Order 1A, His Lordship determined to take it into account and said it's a factor to be taken into account in the court's discretion of whether to set aside a default judgment. But what His Lordship found is that the primary consideration, and I'm looking at page 30 of the appeal, at the top, the primary consideration still remains whether an intending defendant can persuade the court by credible affidavit evidence that he has a real prospect of success. Now, if we may go back to the to page 27 of the record. This is where His Lordship dealt with the substantive issue of whether there is a real prospect of success. And as your Lords are aware, at paragraph 22 of the judgment, the Chief Justice had reference to Mr. Sampson's marine report. And there's that point that President Clark made that on the face of it, the factual position is that the centre console could not be permanently secured to the hull of the vessel. It would accord with common sense that the vessel would not be seaworthy. So the judge has weighed the facts before him, and he has made a common sense finding, a safe one in my respectful submission.
You say he's entitled to do that?
My submission, President Clark, is that on a application to set aside a default judgment, he has to not conduct a mini trial, but weigh the facts before him. I think he's entitled to weigh those facts and to make a determination of that nature. I think that I of course can't place myself in the Honourable Judge's shoes, but I think he's been deliberate in saying that it would accord with common sense. He's deliberately not purporting to be an expert on the subject matter.
Right.
And this really goes to what appears at paragraph 23 of the judgment, the slight predicament that he was in, which is that the only evidence that was before him was not Mr. DeSilva's more substantive affidavit, which we now have the benefit of, but was an affidavit of Mr. Richardson, where he explained why he had neglected to file a defence or neglected to serve a notice of intention to defend, and simply said, in Mr. Richardson's words, were plainly stated, the issue is whether the boat was structurally sound and fit for recreational use in Bermuda's harbour and littoral waters, which the respondents obviously agree with. That is our case. And secondly, Mr. Richardson deposes, this is at the bottom of page 27 of the record, respectfully, the facts of this matter demonstrate that the boat was clearly fit and sound for these purposes. Now, my lords, there were no facts before the first instance judge other than the Marine Surveyor report and the pleadings and Mr. Richardson's affidavit. So this was a bare assertion made by an attorney who's no longer on the record. And I think certainly my submission would be that the Honourable Chief Justice was acting appropriately when he weighed the relative weight of that evidence against the qualified Marine Surveyor report and made what he called a common sense factual determination. That's really the extent of that I wanted to address what happened back before the Supreme Court. Subject to any questions from your lordships, I was intending to turn to my arguments as to why the application for an enlargement of time should be refused.
Yes.
So, Order 2, Rule 4 of the Rules of the Court of Appeal provide that an application for an enlargement of time must be supported by an affidavit which sets forth good and substantial reasons for the failure to appeal within the specified period. Now, in that regard,
But isn't that in the context of an application to extend time because there's been a failure to appeal from the Supreme Court to the Court of Appeal within the fixed time limit, which is not this case?
yeah, it's an interesting question which Mr. Coelho and the parties have discussed. President Clark, are you suggesting that it's not the appropriate, in your view, not the appropriate test for this case?
It's Justice Bell, not the President.
My apologies, Justice Bell.
Yeah. Well, I'm asking you the question.
My friend has made an application for an enlargement of time in which to seek leave to appeal. He's submitted an affidavit of his client setting out the reasons why he was late.
Well, as I read it, he was in fact in time in relation to the appeal from Chief Justice Hagen's ruling to this court. And yes. I get that from, do you agree with that?
I do agree with it, Justice Bell.
So Order 2, Rule 4 of the Rules of the Court of Appeal is inapplicable.
Yes, I think I can concede that point. Nevertheless, if we cast our mind back to what was before the Chief Justice on the application for leave to appeal, we can consider what the intending appellant's arguments were as to why an enlargement of time should be granted before that court. And these appear at paragraph 10 of Mr. DeSilva's affidavit, which is at page 92 of the record of appeal.
Yes.
Bear with me one moment, my lord.
This is where he's saying that the reason for the delay is because he was trying to settle with Richardson.
Essentially, so I should explain that my delay, yes, I should explain that my delay in bringing this application is that I had hoped to settle my case with Mr. Richardson, who Mr. DeSilva says had negligently failed to represent me. He goes on to say the time limit for filing the appeal had expired, but I was hopeful we may reach a settlement. Now, my lords, there was some discussion at the beginning of my friend's submissions as to how late that application was, whether it was 27 days or 30 days. From the respondent's position, that's not the substantive point about how late it was. The point is more that it's all good and well that the intending appellant had a grievance with his former attorney, but I wouldn't want this honourable court to be under the impression that there were any settlement discussions between the intending appellant and the respondents. This was purely a grievance with his former attorney. This wasn't a case where he was putting offers to my clients to make this dispute go away and not trouble this court. So I suppose that my summary submission would be that doesn't seem to me to be any good reason. If you're properly advised, you understand what the timeline for the appeal is, it surely can't be a proper reason to say, I have a grievance with my former counsel. I'm going to try to extract some funds from him. I knew that I was supposed to appeal, but I didn't. In terms of the actual prospects of having the default judgment set aside, we're limited to our consideration of what was before the Chief Justice at the time. And
is that again, right? Just pause there for a moment. Assume that the material that is in front of the first instance judge is lamentably insufficient and doesn't show a realistic prospect of success. There's then a change of counsel, and there's an appeal put forward in time, and evidence of the most convincing kind is produced, which shows that there's a very real prospect of success. Indeed, it's difficult to see how the claim can succeed. Is the court, I know that's not this scenario, but is the court bound to say to itself, well, this evidence was not before the first instance judge, so we're not going to take account of it?
Well, Lord, I'd say that there are circumstances when you can take into account extraneous evidence, but perhaps we could address that point now
Sure.
in the context of Mr. DeSilva's affidavit.
Yes.
Now, if we cast our mind back to where I began my submissions, being that this is essentially a dispute about the seaworthiness of a vessel, where we have a marine surveyor report saying that the bottom of the vessel can't be fixed to the top. While even the draft defence that's been prepared by Mr. Horseman as the impending appellant's new counsel discloses a kind of a handful of positive averments, it joins issue with the plaintiff's, well, the respondent's contention that it was an all-inclusive price. There's no pleading, positive pleading supported by any real evidence that this court can have regard to that deals with Mr. Sampson's professional opinion that this cockpit sole had delaminated. So where we stand today, in my submission, is that there is still no defence before the court. There's still no real evidence before the court, other than bare assertions from the intending appellant, who notably concedes, I think he speaks of the term defect in his evidence. So perhaps we could turn to page 94 of the record. I'm looking at paragraph 21 of...
Sorry, which page? 94?
Page 94 of the record and page
Yes.
21
Yes.
of... when the boat came up for delivery, the respondents had it inspected. The point of contention was the sole of the boat being delaminated to the point where Mr. Sampson said the T-top could not be permanently secured. As indicated above, I corrected that deficiency for approximately $4,000. He goes on to talk about what the court should have done and said, it is fine now, as I indicated. The boat and the T-top withstood hurricane force winds. So how does that, I'm struggling to understand how that materially assists the intending appellant when on the pleadings, we've made the case that he demanded $10,000 to fix what we said was a deficiency. He admits that in the amended defence prepared by Mr. Horseman, and then even in his own evidence, he now says that it was a deficiency and that he had to pay $4,000 to fix it. I don't know where the difference between the $10,000 he demanded from the respondents and the $4,000, which he says in his evidence it cost to fix, but it seems tolerably clear to me that there was a deficiency in the boat. The deficiency in the boat was the same type, the same nature that the marine surveyor had identified, and that he was required to correct the issue before he then went and sold it and retained the proceeds. So if we accept that the court, which I think is appropriate, that the court can take into account new evidence with a new defence, aside from the averments as to the particulars of the contract and whether the boat would be in fair condition or not, the real issue which the judge had in mind, the Chief Justice had in mind when he refused to set aside the default judgment, was this defect, which Mr. DeSilva appears to acknowledge.
You say that he implicitly acknowledges that he had an obligation under the contract to fix it as well.
I think in all fairness, he doesn't acknowledge that. What he seems to acknowledge at paragraph 21 is he says in the middle of that paragraph, I corrected that deficiency. Now, perhaps it's loose drafting, but he's here saying that there was a deficiency. He then goes on to say, it is fine now. In the context of an expert saying the boat has serious deficiencies, the respondent saying, please deliver us a boat that accords with the terms of the contract, i.e. one that is seaworthy. The intending appellant's response is to say, you need to give me $10,000 to fix it. Admits that allegation in his new defense, and then his evidence is that he fixed the deficiency, what he calls the deficiency, for $4,000. That was the substantive matter before the Chief Justice. Is it seaworthy? Was there a deficiency? And it just seems to me that even on this new evidence, that issue is still a live one. So really, you know, my lords, you know, you'll appreciate that my submissions have focused on the topic of seaworthiness. They've focused on Mr. Sampson's report. They focused on what the Chief Justice had before him at the time. The respondent's respectful submission is that the judge was entitled to form a view based on that evidence which was before him. He was entitled to apply the Andrew Mitchell case in determining whether Mr. Richardson's default was a good reason to set it aside. And ultimately, of course, he determined not to. Now, before your lordships in March of 2021, considering fresh evidence, considering a new defence, which still don't appear to have materially advanced or to set out any good reason why an extension of time should be granted, or more importantly, any credible defence to the respondent's statement of claim. And keeping in mind that, you know, the overall course of conduct of this proceeding, where I should of course add that the intending appellant not only has the benefit of the $40,000 paid by the respondents, but he's then sold the vessel and retained the proceeds as well. You know, these matters do invariably cast doubt on the reliability and the credibility of the draft defence. So, unless I can assist your lordships further, the respondent's position is that the application for enlargement of time must be refused, that leave to appeal should be refused, and that an order should be made as to costs.
Just help me. I want to make sure that I've summarized in my mind what you say. You say that an application, you say that start again. You say that the judge was entitled to take the view that the application for an extension of time for permission to appeal to us and for leave to appeal should be refused because no good reason has been put forward for the delay. The fact that there might have been settlement negotiations between the appellant and his former counsel is true but uninteresting because the relevant question is the position so far as your clients are concerned vis-a-vis the appellant, not whatever difficulties the appellant was trying to resolve with his counsel. That's item number one, as I understand it.
Yes, Father.
Item number two is that in relation to the question of the merits, the judge was entitled, in relation to the material before him, to take the common sense view that what was contained in the report showed that the vessel was unseaworthy. And that was effectively all that he had before him when he reached his decision, because the other stuff that he had before him was either Mr. Richardson's defense, which wasn't evidence at all, or the later, more substantive defense, which, apart from a denial of unseaworthiness, did not engage with the basic factor which was said to make the vessel unseaworthy. Is that right?
Yes. the judge had formed the view that it was the defendant's burden to, well, the now intending appellant's burden to discharge, and failed to produce any credible affidavit evidence showing a real prospect of success.
Right.
He had to make that decision based upon, for one reason or another, the affidavit of Mr. Richardson.
Yes, but I think you accept that in certain circumstances, the court may allow a defense to be, a judgment in default of defense to be set aside, even though the evidence that produces a realistic prospect of defense wasn't filed with the judge when the application to set aside the judgment was made. So that there can be circumstances in which
I do accept
rely upon subsequent evidence. Is that right?
I do accept that, and my submission in that regard is that the point that I perhaps clumsily took you through before was that the evidence now before the court, the evidence that was before the Supreme Court on the initial application for an extension of time and leave to appeal, being Mr. DeSilva's affidavit and the new amended defense, still doesn't give rise to any real defense and still doesn't disclose any good reason for delay.
Yes, I mean you talk about the amended defense. What I call the second defense was before the judge. Yeah, and
At the application for leave to appeal, it was, yes.
Yes,
It
absolutely.
was two at the time of the application to set aside.
Yes, it was. Anyway, you say that what I call defense number 2 doesn't show real prospect of success, and you say that the subsequent affidavit of Mr. DeSilva, only before the judge on the application for leave to appeal and an extension of time, insofar as it exhibits the defense number 2, doesn't show real prospect of success, and also contains within its own terms of paragraph 21 an apparent omission of a deficiency in circumstances where it is also admitted that the defendant wasn't prepared to cure the deficiency unless paid $10,000.
That is my submission.
Right, okay.
But much more eloquently. Thank you.
Sorry, I'm being a little slow, but I want to make sure that I've understood it completely. Thank you.
I think the issue is on my end.
No. Do any of my colleagues have any questions?
No, nothing further.
No, thank you.
Right, Mr. Hosman, have you anything you wish to say in reply?
Yes, my lord. Again, I would just refer back to page 39 of the record, which was the affidavit filed in these proceedings in paragraph 9, where Mr. DeSilva said, "I deny that the center console cannot be permanently secured. It was, in fact, already secured appropriately, but as a result of the report, I reinforced the sole by installing a new fiberglass floor." So it does say in the affidavit evidence, and I take the point about paragraph 21, and perhaps wasn't drafted the best, but in paragraph 9, he says that, listen, it was already, in fact, secured appropriately. So I just wanted to refer to that. Other than that, my lord, I have nothing further to add except that there would be a really...
I'm not sure paragraph 9 could be read for those purposes, because it goes on to say it was in fact already secured appropriately, but as a result of the report, I reinforced the sole by installing a new fiberglass floor.
Yes.
So the remedial work was done after the report.
That's correct, my lord. Yes. Yeah, I referred to that in my initial submission.
Yes.
But Mr. DeSilva's point was that the boat was already seaworthy, but in light of this report being out there, he went ahead and reinforced it. I'm not going to go rehash my submissions, my lord. I would just say my client would suffer an injustice if he was not allowed to defend this matter with circumstances beyond his control, as how we ended up here, and I'd ask you to grant leave to appeal or set aside the judgment granted in default so the matter can proceed to trial. Thank you.
Right. Well, we will have to address our minds to two questions. The fact that I'm identifying two questions should not be taken to be an indication that the second question necessarily arises. But the first question is whether or not the judgment should be set aside. And the second question, which only arises if the answer to the first question is yes, is whether any, and if so, what conditions should be made if we were to take that course. Would it be
Yes.
convenient for the parties to indicate their position on that?
Well, I think, as I indicated, my lord, that one of the avenues the Chief Justice could have taken, was to impose conditions. I mean, that was my third ground of appeal, rather than just shut him out from the seat of justice and allowed him to pursue it, whether that was some type of payment into court or the like. I mean, we would certainly ask for unconditional leave to defend, but as a fallback position, and which one seems apparent that wasn't considered in the judgment, with some sort of conditions, which of course the court can impose on it in the event that they feel that it's required.
Yes. Well, unobvious possible condition is that the money in issue should be brought into court.
Yes, ma'am.
Okay. Right. There may be others.
Yes.
Is there anything you want to say about that?
No, my lord, other than to I guess, make the obvious observation that this is now the third contested hearing in these proceedings.
Yes.
No serious costs have been incurred. The intending appellant has the $40,000, has the proceeds of sale, and no stay of enforcement has been sought. So enforcement efforts are actually underway at the moment. Suffice to say they're not going smoothly. I think that's all, just to give you some context.
Very good. Well, thank you both very much.
Thank you, my lord. Nice to see you again.
We shall take time to consider.
Yeah, my lord, Justice Valley, Justice Bell, to you as well.